Just again, you've seen this slide before, but by way of warm up, these sessions have followed along with the format of the Land Trust Standards and Practices, which is a body of guidance compiled from within the conservation community and kind of codified and held by the Land Trust Alliance. And the standards and practices are comprised of 12 standards that address different topical areas that are common to land trust practice. The first half of them, 1 through 7, are common to all nonprofits, and the second half are specific to land conservation. And they also filter down into 4 general buckets: governance, finance, land protection, and stewardship. And tonight we are doing stewardship, which is practices 11 and 12. And then again, just briefly, a review from our session last week on land protection. Since many of you are new, land trusts protect property in 2 major ways. And the first is through ownership of property, which in legal terms is called the fee interest. So we might say fee properties. And the second way is by acting as the oversight organization, the easement holder for a private property, which is restricted from development. So we hold the foregone rights to development. We hold the private landowner to their promise. And this is called a conservation easement or a conservation restriction. So it's typical that you're going to hear your organizations making a distinction between your fee and your easement properties. Last week, we talked about the protection component of land trust work, but that is really only the beginning. My slide title here, "We've Protected It Forever and What Now?" Alludes to the now perpetual need to look after the protected land. Stewardship is really a catch-all term for how we take care of the properties we've protected. And stewardship differs depending on which type of property we're talking about, easement or fee. Conservation easements are encumbrances on the land. So land trusts that are holding conservation easements do not own and therefore don't manage those lands. And absent some special and additional arrangement, which does happen, land trusts are not doing anything on those lands besides monitoring them. They don't mow them, they don't make trails on them, they don't remove invasives or trash from them, but they do monitor them to ensure that the landowner complies with the restrictions, which, by the way, might entail making the landowner remove that trash. Conservation easement stewardship is about making sure the landowner abides by all of the contractual conditions in the easement agreement, and that includes making sure that other people also abide by these conditions. So the land trust is responsible for making sure that the landowner doesn't allow things that wouldn't be allowed on the conservation easement or restriction. So let's see, when there are situations of non-compliance, the land trust stewardship responsibility is to try and bring things into compliance, and we call this enforcement. And that can be really time-consuming and costly. More on that in a little bit. Conservation easement stewardship also might be about paying careful attention when landowners' rights that are reserved in the easement agreement, such as rights to build structures or engage in certain activities, are exercised, to make sure that the landowner is doing this in the way that's envisioned by the easement agreement and not harming the conservation values on the property. And this, again, can be kind of time-consuming and costly. Our obligation to do these things in connection with easements is connected to our qualification to hold the easements in accordance with Internal Revenue Code provisions as well as state law, right? So it's really a contractual arrangement more than fee land stewardship, which is really about ownership. And the stewardship of fee properties can vary depending on the property and the purpose for which the land trust protected it. So we do own these lands and we have far more leeway because of this, although what we can do with them might be limited in some cases by deed restrictions, conditions that are connected to project funding or grants, or by our own public service missions. Land with no public access and a forever wild strategy might involve less activity in comparison to land that's managed for wildlife species or with trail systems or buildings. But whether an easement or a fee property, stewardship should always be focused on the continued protection of the natural resources on the property, as well as making sure that the property's conserved status and the land trust rights to the property are also maintained, and engendering trust in the conservation community overall. So whether easement or fee, this really starts with regular, which we mean at least annual, informed monitoring of the properties. Okay, effectively monitoring and enforcing easements and managing properties basically takes money, personnel, and policies and procedures. So personnel, whether we're talking about volunteers, contractors, staff, or a mix of all of these. And this is really what standards 11 and 12 are all about. The stewardship practices can get pretty detailed and case specific. So for those that are not primarily responsible for stewardship in an organization, we're going to really talk about the high level stuff that every board member should know. We may go just a little bit deeper into monitoring because many times the board, a volunteer board's role will include monitoring of some properties. All right, so let's begin with the money part. And we've covered this a little bit during our previous sessions. Thinking about the prospective costs of stewardship begins when the project is in the planning phase, sorry. When it's not yet the responsibility of the land trust, you'll be thinking about what it is that you might have to do. So we learned in our finance session that land trusts should have financial reserves in place to provide for their ability to steward their easement and fee properties in perpetuity. And this includes reserves for monitoring the properties as well as taking any action needed to defend them. And for fee properties, it also includes any active management of fee properties that's required pursuant to the deed or by a donor or the transaction contingencies or agreements. We've discussed previously how using actuarial data, including that collected through the Terra Firma Conservation Defense Insurance Program, the Land Trust Alliance developed a calculator tool to help land trusts estimate their potential financial exposure in defending their easement and fee property interests. So you might want to use that calculator during your project planning. So you might want to complete it with your current suite of properties and then do it with the additional property, seeing what the difference is to have one more. And make sure that you have at least those stewardship reserve funds on hand. The calculator provides a minimum suggested level of defense funding, but as we discussed in our session on land protection last week, for each new project, land trust should really be thinking about the prospective stewardship needs of that individual specific project, because those needs might be lower or higher depending on the characteristics of the property. So we use the example of an easement that has low prospective costs because it has few reserve rights, is easy to monitor, with low potential for encroachment. So say like a 5-acre parcel with no structures, no reserve rights, easily ascertained boundaries, and compare that to an easement that maybe has 450 irregularly shaped acres. It's bounded by several subdivisions under development and many reserve rights. So that would be a really high cost easement that you would budget more for. And this is only, by the way, for legal defense. So in addition, you are going to want to have reserves on hand to cover the perpetual monitoring costs, and how much you put aside should be informed by tracking every year your monitoring costs. And for organizations, just to I guess just to allow for those organizations that are right now are not paying for stewardship or taking care of their stewardship through volunteer monitoring, what you should be doing is tracking the volunteer hours and assigning a cost to them so that you know basically what you might need to pay if you weren't able to have volunteers do this for you in the future. As mentioned before, monitoring is the most important and first step in fulfilling one's stewardship responsibilities. So here on this slide is the text of Standard 11C and 12C regarding procedures for easement and fee property monitoring. Standards 11C and 12C both say that monitoring should happen at least once per year, and more often when necessary to observe changing conditions or follow up to observed issues. So if there has been an exercise of reserve rights, for example, or following a storm, that might be a good time in, throughout the year to check on an easement or a fee property. The text differs a little bit between standards 11C and 12C, but the idea in 11C that a good policy or procedure will help provide consistency and guidance for those doing the monitoring and should cover monitoring responsibilities, activities, and record keeping. That is all appropriate for fee properties as well. So the language is not repeated, but it really is applicable. It's not as if you shouldn't do that for your fee property monitoring. And likewise, the idea that aerial monitoring, which is becoming more feasible with technological advancements, should be supplemented with on-the-ground monitoring is sound advice for both easements and fee properties. And the idea that knowing property boundaries is essential for being able to conclusively know, in many cases, whether or not there's been an encroachment. That goes, again, for easements as well as fee properties. Whether easement or fee, monitoring should be documented, and issues that have been observed should be addressed through appropriate follow-up, whether easement or fee. Right, great. So what might a monitoring process look like? Generally, it's going to be something like this, once a year or more often if necessary, if something is going on. Hold on, I got to get the poll window out of my slide. Whoever is the monitor, and this is for this group, usually going to be a volunteer, but might also be staff. That person will prepare for the visit by reviewing documentation about the property and recent activity. So this would include, for a conservation restriction, the restriction agreement, the baseline documentation report, and prior years monitoring forms and maps. For a fee property, you'd want to look at the management plan, you'd want to look at prior years monitoring and anything that you've got on file about what is happening on the land, just to brief and remind yourself about what you're going to take a look at. It would be a good idea to have copies of these available during the field visit, and that could be in paper or it could be something that is cloud-based or digital if you wanted to download things before you went, or if you have a connection, although that's not always available on our conservation properties. You might be accessing it on your phone or a tablet. In addition to these records, the monitor is going to want to bring along identification as a representative of that land trust. So, frequently a business card, maybe a car magnet, safety equipment as appropriate. So training for monitoring should address things like whether there's self-coverage in the properties, ticks, bears, things like that, and equipment. The monitor should bring equipment to help document issues or make future monitoring easier. So flagging tape would be a good thing to have in a backpack, maybe with that safety equipment. Definitely a camera to photograph possible issues. And a device that helps with navigation, whether that be a special GPS or maybe your smartphone, would also be a good call. After the visit, the monitor completes documentation of the visit, and we'll look at some sample forms. Somebody's walking in my door. Sorry. We'll look at some sample forms a little bit. And some trusts are doing this on paper, but some are also doing this digitally now using software, or maybe like a Google form would work as opposed to writing on paper. The documentation is then reviewed by another person at the organization, maybe the committee chair, the stewardship committee chair, leadership staff or board, to help direct necessary follow-up for the organization. So there are some special considerations for conservation easements. You're bringing somebody else into the mix because there's a landowner. So some organizations extend an invitation to landowners to join for the easement monitoring. Violations with easements can be really tricky and time consuming, as I said. So landowner relations are really important as a proactive strategy to prevent violations. So for this reason, many organizations will either use their paid staff, or they might use like the same board members each and every time to do easement monitoring, to develop a relationship with the landowner for consistency in the monitoring and the messaging and familiarity with all of the mapping. But also most organizations will have a policy that no monitor should discuss with a landowner on the date of the monitoring, like whether or not certain conditions are being met or certain conditions are encroachments or violations. Generally speaking, the observations are brought back to the organization, and you would examine the documentation before any conclusive statements would be made to the landowner. Some organizations send a copy of the monitoring report to the landowner. There are pros and cons about doing this. In some ways, you're creating a record. So, if the letter says there are no violations, just be aware that you're creating a written record that the land trust did not believe there was a violation as of a certain date. On the other hand, it's also really good. It's a good way of doing landowner relations, building relationships, touching base with the landowner about certain things that are important, that are important to them about their property. So it can be a really good engagement technique. Okay. Here's an example of an easement monitoring form. There's no one set required form, but there are a couple of things that I like about this one. You can see here where I've highlighted in yellow that there are prompts for the monitor to record information about activities taking place on the property and whether or not these are consistent with the easement. And there's space down further for further examination when you're back at the office or with the easement agreement. It's grayed out to kind of suggest that this part of the form should be filled out later, flagging issues filled out by others, maybe subsequent to the monitoring visit. So that's one form. And then I also have a sample fee property monitoring form. Again, no set form for this. But one of the things that I like about this is you can see where there's been space added up top to prompt preparation for the visit by reviewing documents that are on file about the property, such as maps and the management plan. The form also has prompts to examine things that might be consistent with the land trust management of the property. So if there's a trail, is the signage adequate? Is the infrastructure adequate? And there are also habitat related observations like the presence of invasive plants. Just as a caveat, be aware that a form like this, which provides a lot of opportunities to comment on many aspects of the property, can lend the appearance of not being complete or done in a less than careful way if the blanks are not filled out. So if it is your process not to require completion of all of the empty spaces, you might want to make this clear in a written procedure or training materials so that it's clear that it's okay for not every single blank to be filled out on the form. Ultimately, we're shooting for documentation that's credible and shows that the monitoring was completed with care and attention to the individual characteristics of the property being assessed. All right, so what's on the monitoring form? Whatever customizations might be appropriate, here are certain things that should always be included. You want the names of whoever was present for the monitoring. You want the date of the visit, obviously. And observations that are related to the conditions in which the visit was made. So like the duration of the visit, what the day was like maybe. These lend to the credibility of the report. And reports that read the same kind of year after year might be accurate, but they can look suspect. So seasonal and weather conditions can really impact what's observable during a visit. And so you should just make sure that there's a way that you can build in something that makes each monitoring form a little bit different year over year. You want what happened during the visit. So where did the monitors go? What did they inspect? All the boundaries, one of the boundaries, two of the boundaries, the interior. Observation about the condition of the conservation resources that are protected on that property, observations that are related to any risk to these resources. And for fee properties, you're going to want observations that are related to the organization's management of that property. So like, does this trail need maintenance? Does any of the signage need replacing? For easements, any noted activity that could be in violation of the easement, and then photos that support those observations. And my personal opinion is that you don't want photos just because, just to take photos. You should take photos when there are potential issues or things that need follow-up. But if you're taking photos when there is no issue, they might not be very helpful, and you're creating a really voluminous file. So if you have, if you have kind of a baseline of what things look like, then I would only personally take a photo if things changed or if there was something that needed to be addressed. Okay. We're almost ready to stop for some questions. You've been really patient. I went really deep into the discussion of monitoring because board members in smaller organizations often serve as volunteer monitors, and that's borne out with us today. As well as, the board members are often the ones that are recruiting, training, and supervising non-board volunteer monitors. So for this next slide about practice 11B, which is baseline documentation reports, I'll be a little less in the weeds. Because what you need to know as members of a board really is that baseline documentation reports are highly technical documents. They're really best prepared by qualified and paid professionals. Baseline documentation reports, which we touched on a little bit last week, BDRs, are needed for each and every easement, but only easements. So BDRs are not completed for fee properties.
Can we actually take a question or two on the slides you just did before we get into this, or do you want to do the break a little later?
No, you know what? Why don't we take a question? That's fine.
So Jeffrey's asking, what's the rationale for monitoring fee properties regularly? I understand easement yearly monitoring, but is it necessary to monitor fee simple properties every year?
It is, and the rationale was really related to the reason that you protected the property to begin with, right? So you protected the property because you found that it had conservation value, that it was consistent with your mission as an organization, and that it provided a public benefit. And so your monitoring really is to check and make sure that that is still true and that you're protecting what it is that led you to conserve that property. So, there are other, you might say, oh, if the property was purchased using public funds, then you have like an obligation under charitable trust law to make sure that you're not, compromising the economic value of the property. I mean, it would be one of the things that you are monitoring for is anything that could cause you to lose the property, certainly, although many of us purchase title insurance. But really, it's to keep an eye on the property, make sure that it's doing what you expected it to do when you protected it, and identify any management issues that you might want to do differently in the next year.
Now, Anne has a question that I think we might want to, I suspect you may want to hold, but it's about what steps can be taken when there are consistent violations of an easement. You're probably going to go there a little bit later, but.
We are. And I think I'm going to rush through my slides so we can get to some of those.
Okay.
But yeah, we'll talk a little bit about enforcement. And some enforcement questions are kind of case by case, so we may want to just dip into that a little bit more in more detail. Anything else right now?
Well, I think you could probably go ahead given what you just said. Maybe I'll let you carry on and then we'll circle back.
Yeah, okay. So just to quickly go through baseline documentation reports as distinguished from management plans, what you really need to know is the BDR should be prepared by somebody who's a qualified professional, somebody who is not only a qualified professional, but qualified to speak about the resources that are being protected by the easement. So if you had an easement that was protecting wildlife habitat, you'd want somebody maybe with, who's an ecologist. If you were protecting farmland, you might want somebody who's got some soil science background. There are people who are more qualified to speak depending on what kind of an easement it is. And when I talk about qualified to speak, what am I talking about really? It's the BDR is prepared for the eventuality that you may need to go to court to enforce the easement. So the BDR is prepared as a piece of evidence that can be introduced, in a later litigation, should that come to pass, that you have to defend that easement. But it's also really useful for monitoring, frankly, because what BDRs have in them is a very good description of the conservation values and of how the easement protects those values, using text, using maps, and using photos. And so the baseline documentation report becomes one of your best offenses to prevent, to head off you needing to defend this easement in a court of law. And when there are substantial changes, so baselines really are like a snapshot in time. They get done at the time that the easement is granted and signed by both the landowner and the land trust, maybe even at closing. If not right during the closing, then as contemporaneous as you can be to the closing. And if conditions change over time, you can update an easement, but you're never going to throw out what came before, right? You're never going to throw out that initial snapshot that has the meeting of the mind between the landowner and the land trust at the time that the easement was granted. That's a little bit rushed on that, but I can take any questions about BDRs. For fee properties, in contrast to a BDR, you're going to do a management plans, and management plans can really be pretty flexible. They should be completed, if you're going to be true to the standard in practice, within 12 months after acquisition. But really, I believe that the best time to create a management plan is during project planning. That is the time that you're going to be thinking, at least in a very initial way, about what it is that you hope to do with the property, what its conservation values are, what your overall management goals are, and what the activities are that you need to do in order to achieve the goals on that property. So management plans are kind of iterative. I wrote dynamic here. They are the kind of thing that you can change up as often as it is necessary. They should be updated at least every 5 years. And they can start out, as I said, in the project planning phase with something that's like a simple sketch, 2 pages long, right? But it's the kind of thing that you're going to build on as you get to know the property and its needs, and conduct, maybe for some properties, not for all, but for some properties, certainly, a considerable amount of activity on the property. All right, so I did have a stop for questions. I don't know if we want to stop now or just forge a little ahead, to get into like enforcement and amendments and all of that.
Well, how about if we circle back to one, first of all, there was a comment that making a map using ideally GPS of where you went on the property is very helpful when monitoring. That was a comment.
Absolutely.
And then a comment from Elise, I can see the benefits, but what are some of the cons of sending the landowner a copy of the monitoring report?
Yeah, so, well, you want to make sure that the monitoring report is well filled out, accurate, and credible. So, you would want to have somebody review the monitoring reports and make sure that you feel comfortable sending a copy of it to the landowner. Also, a monitoring report like the one that I showed you, that's all about, is there a violation, and has space for considering that kind of thing, could be off-putting to a landowner, could be, could be alarming if there actually is a violation. And so I would, to me, it may depend on your form, it may depend on your relationship with the landowner, and you might want to think about, if you're not, not sending a form, but sending a letter out to the landowner saying, we came out, we observed nothing, no violations, thanks very much for taking good care of your property, or something like that. So you may decide to do something that's a little bit of a hybrid.
And the only other one right now is the one about the consistent violations of an easement. So maybe you want to go ahead a little bit further before.
Yeah, so let me go to the next slide on that, and I'll see if I can address that. I'm sort of ad-libbing on my script now, because we're a little bit behind, and because I think that this question is a little bit more than what I normally would do. Conservation easement enforcement as something that you do when monitoring has uncovered like a breach or a violation of the easement agreement. And the topic itself can be really case specific. We could go over all kinds of different scenarios. What I think is important for a board to know is that each and every violation does need to be addressed, right? So it goes back to our responsibility to the IRS or to the state as qualified easement holders, and failure to address a violation could jeopardize our tax exempt status. Also could jeopardize our standing with other easement landowners, right? So, if we're lax with one, maybe that makes people think we'd be lax with others. And of course, the public's confidence in easements and conservation. So all violations must be addressed, but how you address them, can differ depending on the magnitude of the infraction. Right. So some might be handled with a friendly conversation and a letter. If there isn't a huge impact to conservation values, sending a letter every year just to make sure that the landowner knows that you still know that there's a violation. Others, the most severe, really might require the involvement of legal counsel. So if conservation values on the property are being severely impacted, that's something that you really want to make sure is addressed. So, if there is an easement violation and, you've reached out again and again and again, and there's no response, you're going to have to, in your land trust, make a calculation of whether or not the impairment to conservation values is so severe that you've got to take it a step further. And you've also got to think about the cost benefits of going further, right? So you might just decide to send a letter year on year, or you might actually involve legal counsel and start some legal proceedings. To me, it can be really helpful to have a policy and procedure for investigating and resolving violations. Hopefully your organization encounters these situations infrequently. And so having a policy and procedure can kind of regularize that if you're not doing it every day. It allows the organization to be consistent and objective. And I've really found that many land trusts use a variation of the same template that's available on the Land Trust Alliance's Learning Center. If that's something that you're interested in doing, it's pretty easy to find if you go into the Learning Center and look up the resources around Standard 11 Practice E. I had a poll. And if we want to take any follow-up questions on that question about the frequency of easements, we can, of violations, then we can.
Well, and Anne asked an interesting follow-up. Is it ever possible to vacate an easement? Like to maybe terminate it or abandon it, or to just,
I mean, in theory, could it ever be possible? Maybe, but that is not something that you want to do. That is that does not engender any trust in the organization and in conservation easements. They are meant to be perpetual. I suppose if the conservation values that you're meant to be protecting in the easement go away and there's no longer any protective value in the easement, it might be something that you could get extinguished. That is, to me, something that you'd want the involvement of a court of law in determining and an order, so that it's clear that the land trust alone didn't make a decision, or the land trust did not make a decision with the landowner. But as you'll see, because I have a slide or two on amendment, it's really not something that we should be doing at all, especially if there's a negative impact to conservation values. So just because there have been repeated violations does not absolve the organization of continuing to hold the responsibility of trying to get the landowner to comply. So
You
So
can see the results there.
55% on the call don't know if there is a violations policy. So if your organization holds conservation restrictions or conservation easements, that might be a good thing to check on. Look in the board manual and see if there is one, and bring it up if there isn't one, especially if you're dealing with some violations. It might be a good thing to check out and put in place. All right, we did a lot on landowner relationships already. The key to avoiding defense is a good offense here. So developing relationships with the landowner is something that can be really valuable and is covered by Standard 11D. A common tactic for a land trust is when there is a new easement landowner going out to meet and greet that landowner, like, hello, this is us. This is what we do. Welcome to the neighborhood. Here is a copy of your easement. If you don't have one already, here's a copy of the baseline documentation report, which you probably don't have because usually they are not recorded on the books the way that conservation restrictions are. Do you know what this conservation restriction means? Are there any questions that we can answer for you? Can we go out? Should we go out and walk it together? Do you know what, why this conservation restriction is here and what it is that's important about your land in terms of its, its conservation values, and just establishing that relationship right off the bat. It's also common for land trusts when they go out to do their annual monitoring, if they're joined by the landowner, to, depending on the relationship, to ask the landowner, like, hey, any plans, in the near future to transfer this land? You're going to sell it? Maybe a family member is moving here, anything that we should know about now. Landowners aren't always upfront about that, but you might as well ask. And then typically what organizations can also do is check public records to make sure that there have been no transfers, and that you can do on a yearly basis, maybe right before you do your monitoring, just so you know if there's been a surprise transfer and there's a new owner. Okay, another area of conservation easement stewardship that benefits from some regularity in business practice is how you respond to landowner requests for approvals to exercise reserved rights. In some conservation restriction documents, a landowner must get the organization's consent in order to exercise a reserve right. In others, there's just a notice provision, but knowing, what those conditions say and what the land trust is entitled to when there are changes on the property is something that is good to have. You might tabulate it, in a spreadsheet about your easements, for example. And when you do get those notices, and if there is any response required, having some sort of a procedure for how you would evaluate and then respond to those requests, and what the timing would be on that to make sure that you do that in a timely manner. And then, of course, anything that you do in respect to the exercise of a reserve right, it should become a part of your permanent record of what happens on that easement, especially if a reserve right is exercised, because then it's extinguished most of the time, right? So that landowner doesn't hold that right anymore. All right, practice 11H is about easement amendments. And again, this is an issue that can be really complex. It's pretty case specific, and it's generally handled by people in the organization that are responsible for leading the stewardship program, as opposed to just people who are especially non-board volunteers. It's treated with intense scrutiny by the IRS. And amendments should really only be done in the rarest of situations after careful analysis pursuant to a board adopted policy, and very well documented for the files. If an easement is amended, there should never be a net loss to conservation values or a private annulment or impermissible private benefit to the landowner, right? So those are the two things that are usually part of an analysis that is in a conservation easement amendment policy. That dual analysis of, if we amend this easement, what happens to the conservation values? We want them to either be no net loss or to increase in value. And if we amend this easement, are we conferring a private benefit on the landowner? And what is the value of that private benefit, right? So here, again, it's really, really helpful to have a policy. You're not going to be doing this every day. You might have a policy that strictly exists for your ability to say no to a landowner. Like, no, I'm sorry, we can't do that. It's board policy that we can only do an easement amendment in these very narrow and rare circumstances. So I have a poll again, which is whether or not your organization has an easement amendment policy.
Connie, can I serve you a couple of questions while that's up?
Yeah.
Somebody asked, do sellers or realtors have an obligation to notify potential buyers of conservation easements? And somebody commented in the chat that wouldn't they be recorded and go with the property, perhaps come up in the buyer's title search? But what's your response to that? The obligation or the duty to inform potential buyers?
I don't know if there's like a legal obligation. I think that a buyer might have some sort of an enforceable right against the real estate agent if they didn't find out about the easement and there was some sort of a monetary damage. But yes, easements and conservation restrictions are recorded on the land records, and so it should come up in a title search. It should be something that would be very obvious to the attorney that's handling the purchase. So the buyer's attorney is somebody who I would think would be responsible for, for finding out about and noting that there's a conservation easement on the land, in addition to the realtor. Realtors sometimes don't want to mess up their sale. Right. So if they're not sure that the buyer would like an easement or would know what that meant, or maybe they would stray away from a property and buy a property unencumbered just because, it in theory could be less hassle. I would say that, that's more on the buyer's attorney to make sure that they surface that and talk about it with the buyer.
You can, I don't know if you want to comment on the amendment policy poll, and I can get that out of the way, but.
Sure. Yeah. Sure. So with 30% of your organizations not having an easement amendment policy, I would say if any of those organizations are organizations that hold conservation easements, that it would be of great benefit to them to seek out a policy and get it on the books before they find themselves in a situation where there's an amendment requested, because it really can provide a really objective and regular roadmap for how an organization might find their way through one of these things.
Now, there are a couple more great questions, but do you have a couple more slides or anything you want to do first?
I do. I have a couple more slides. There really aren't that many, so maybe we could plow through them and then just use the whole rest of the time for questions. Okay. Practice 11J is also about easement amendments, even though it's called partial or full extinguishment. This is a practice that is specifically addressing this thing that some people refer to as a land swap, right? So this is when a landowner has either done a violation or requests an amendment, and they're saying, I don't want to undo what I did, or that's too hard. And so we're going to carve out this portion of the easement and, extinguish that. And instead, add on 20 acres on the other side of the property. And it's those situations really get even more scrutiny from the IRS and deserve even more thought to think about the impact on the part of the easement that is being suggested that, that part goes away, right? Because if there are conservation values on that portion of the property, and extinguishing the easement would impair those conservation values, then the IRS is going to not look favorably upon this. In fact, the whole term of a land swap is a little bit of anathema, to the Internal Revenue Service. So try to avoid those kinds of situations if you're doing an easement amendment. Know that a land swap, although it may seem at first to be an elegant solution, is really not the solution that you want, particularly because it does terminate the perpetual nature of the easement, at least on that acreage. All right, my questions slide. And there are just a couple more, getting to the end of 11 and 12. Standard 11 practice G and standard 12 practice D both deal with contingency planning. And that really is something that is promoting having a backup organization ready to assume responsibility for your conservation properties in case your organization becomes unable to fulfill its stewardship responsibilities, or if it decides to dissolve. Right. So sometimes this kind of a contingency plan is done within an easement agreement. So sometimes there is a backup holder that's named in the contract itself. Sometimes organizations' articles of incorporation specify who the backup holder might be. And sometimes contingency plans are made as organizations build relationships with their peers. So more this consideration, the consideration of who your backup might be, could be a major factor that's leading an organization to begin thinking about merger. All right, standard 11 practice I and standard 12 practice E both deal with condemnation. I think that condemnation is a pretty rare occurrence today. I don't myself have any personal experience with a conservation property that was condemned. But I do think that it may become more common in the future as pressures for land use increase. So what these practices advise you to do is to try to avoid or mitigate harm to the conservation values on the properties, and for the organization to really carefully document their efforts during condemnation proceedings to protect conservation values, to retain some economic value in a property if possible. But they don't require, there's no expectation that an organization will absolutely exhaust their financial resources and ignore their other work fighting condemnation proceedings, which ultimately will rarely be decided in their favor, right? So there's this idea, try to protect the conservation values. If you have a monetary value, if this is a property that you've booked on your balance sheet, and there is a condemnation, make sure that you get some kind of a proportionate interest in what comes out of that. Rare. And again, my top 5 takeaways. So number 1, regular monitoring is critical to a successful stewardship program. I bet you got that from our discussion tonight. Number two, management plans provide helpful guidance for land trust actions and interventions concerning their fee-owned properties. They guide your annual work plans and your budgeting and your long-range strategy, and they can be revised when appropriate. That maintaining good relationships and communications with easement landowners and property neighbors of your fee properties can head off problems such as violations and encroachments. Number four, that good documentation, including signed baseline documentation reports, provide the land trust with evidence in the event that enforcement requires legal action. And documentation is also going to be helpful if the land trust ever transfers the property to another conservation organization. So your backup holder will benefit from your stewardship record. Finally, easement amendments should be avoided, but in rare circumstances, they might be considered pursuant to a written policy that ensures no net loss to conservation values, no private annulment or impermissible private benefit, and an amendment that's in line with accepted guidelines that are published by the Land Trust Alliance. So that's what I had.
Lots of great questions, actually, and I don't know if we'll get to them all, but you've been talking a lot about conservation values, and Todd has a great question. How does one measure conservation values? Is that something that you would appraise, or how do you really determine, how would you measure those?
Well, you're going to start in your project planning. So if you remember from last week in the land protection phase, we talked about how in standard 8, your project selection is going to depend on what your organization's individual and unique protection criteria are, right? So usually organizations' project selection criteria will name conservation values that the organization seeks to protect, right? And you might have a weighted system that actually even, assigns a number to the conservation values that are associated with a specific property where you're doing a project. The conservation values are also identified and documented when you go out to do your site visit as you're putting your project plan together. And then depending on if it's an easement or a fee property, the conservation values are going to be described and documented in that baseline documentation report, if an easement, and in your management plan, if a fee property. So that's where you're going to look if you're thinking about, encroachments and responses to encroachments, or if you're thinking about amendments. And so you're not really appraising that. I mean, that's where, your conservation organization's judgment is going to be particularly useful. What you are going to appraise in the case of an amendment is whether or not you're going to, an appraisal is going to be important to determining whether or not there's an impermissible private benefit. So you might hire an appraiser to do a before and after. What's the value of the property if you don't amend it, or what's the value of the property now that it's been violated in this way? Your landowner cleared away all the trees and built a pool, right? What's it look like? What was the, and what's the value of the property had they, had they adhered to the easement? So finding out that differential in the case of either a violation or a prospective amendment is how you're going to determine whether or not there's been an impermissible private benefit. And if there's an impermissible private benefit, you really cannot do that amendment unless there's some sort of a balancing of that equation.
But really, appraised market value and conservation values are sort of two different concepts. There's another question. Well, I'll note the time, but we are at time. So if any of you need to leave, we'll take that. But maybe we can squeak in one more question. If a new landowner completely ignores the existence of a CR on their land and begins building, for instance, can cease and desist orders be used to stop the infraction?
Yes, and you should look into the document itself, because sometimes there are specific provisions about that. I mean, what you would be doing is getting some sort of injunctive relief because of the irreparable harm that is being done to conservation values. So So yes, that is something that is generally available to land trusts in enforcing an easement. And the first place to go is within the four walls of the easement contract itself.
Now, there's an interesting question here about, what happens if you hold an easement, but then you come to own fee in the same property?
That's a really good question. And it depends on state law, really. And this is the concept of a merger of interest. So, not merger of organizations, but merger of interest. And so some easement agreements have specific clauses in them to kind of protect against that. So merger of interests, the bad thing that is imagined there is that if an organization holds an easement that is meant to be perpetual, but then the land trust becomes the owner as well, that there's a merger of those two interests, that the land trust can't be, and this is usually dependent on state law, sometimes on case law, the land trust can't be the owner of the fee and hold an easement on it. And if that happened, then that easement would no longer be perpetual, which would be a terrible thing in the eyes of the IRS, because easements must be perpetual. So in many easement templates, there's a clause that says, there's no merger of interests if that happens. And strictly speaking, there's a conflict of interest if the landowner remains the easement holder over property that it now owns, because, who's going to enforce it? Who is going to hold the land trust that's the landowner to the restrictions that are in the easement? We all know that we wouldn't do anything to harm the property, but strictly speaking, there's a conflict of interest. And so what many land trusts would seek to do in the case that they became the owner of the underlying fee property for which they've had a conservation easement is that they would try to transfer that conservation easement to another conservation organization.
Well, that's great.
For a land trust to have, one or two easements like that where they became the owner.
Yeah, so that was a great question. There's more questions, but I think given that we're over time, we probably should respect everybody's time. You're getting some thanks in the chat, and we appreciate everybody participating. And I will be sending out a little note with the link to the recording, and also a link to an evaluation form we'll encourage you to fill out. So thanks for joining us for these 5 weeks. And thank you, Connie, for doing a great job covering a ton of material.
You're welcome. It's a lot. Please do fill out the survey. It's really helpful for me to know what parts of the series you found to be most useful to you, and we can tweak it up. So I really, again, so appreciate your participation, your terrific questions, most of all, your dedication to your organizations. Thank you so much for your service. And I think that you have my contact. So should you ever need to reach out with a question, please do.
Great. Well, thanks everybody, and have a great night.